in which individuals appear both in person in courtroom G33 at 160 Prior Street, as well as have the opportunity to appear by Zoom. This morning for October 20th, 2023 at 9 a.m., we're going to commence with our motions calendar, and I'm just going to do a brief roll call to see who is present. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have the right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one would be appointed to represent you. The first position I have is Leonard Bennett. Mr. Bennett is now retained counsel with Ms. Maureen McLeod, who's present in court. Ms. McLeod, have you heard from your client?
I have not.
All right, so we hope you'll appear shortly. Okay, this is Mr. Bennett's motion for a new trial. So hopefully he'll appear to address that. Thomas Allen Cotman.
Good morning, Judge. That's my case. Mr. Cotman is present and we are prepared to move forward with our motion to suppress.
All right. And the state prepared with their witness?
Yes, Judge, we have one officer that's here. I have another officer that's on his way. He should be here shortly.
Officer,
This is Officer Tran. Tran. And I'm waiting, Lieutenant Peter.
So sorry, Judge.
Lieutenant Peterson,
Lieutenant Peterson, okay.
is coming.
Ms. Rosen, I think you have to mute your screen.
Yes,
Yes,
Judge,
Judge.
sorry about that.
Okay, perfect. Thank you. Did you say Lieutenant Hoover?
I'm sorry,
Lieutenant
Peterson.
Peterson? So I got caught up with Miss Hoover's. Rosen Hoover.
I'm so sorry. everybody.
Lieutenant Peterson, okay. And then position 3, I have Jaylen Gil.
Yes, Judge, that is also my client. Mr. Gill should be appearing over Zoom. He did just email me if I could have a moment to
Okay.
ensure his appearance.
All right, with respect to position 4, Jeremy Swan. I understand that that case has been closed out pursuant to a null pros order issued on September 27, 2023. So no one need to appear for that. Was that also your client, Ms. Rosen?
Yes, Judge,
Okay.
and that's my understanding as well.
All right. So at the present time, I call State versus Thomas Allen Cotman. Ms. Rosenhoover, you can have Mr. Cotman seated next to you or in the first row behind you. How would you like him to be located?
He can come sit with us, Judge.
All right.
And Judge, before we start, I will need Lieutenant Peterson to testify first. So
Okay, so he's on his way.
he's on his way, Your Honor.
All right.
Yes.
And
But if we want to put the issues on the record.
okay, we're recording this proceeding, so that's how the folks are going to get a transcript. Do we have a court reporter on the Zoom? Yeah, we have Miss Allen.
We have Ms. Allen,
Okay.
yes.
Yes, I'm here.
All right, Ms. Allen, we're going to start with a preliminary on this particular motion. So this is case 21 CR 007316F. State, no, excuse me, scratch that. Oh, no, that's correct. That's correct. This is State versus Thomas Allen Cotman, Cottman, who's present in the courtroom and represented by Public Defense Counsel Sarah Rosenhuber. Mr. Cotman has been advised of his rights at the beginning of the calendar. Mr. Cotman was accused of DUI, driving under the influence of alcohol per se, DUI, driving under the influence of alcohol less safe, possession of an open alcohol container, and failure to have a license on person, stemming from a February 28, 2019 incident. Defense counsel has filed a motion to suppress the pursuant to Jackson v. Deno, as well as supplemented the motion. I'm not certain who's going to be testifying for the defense, if any. But right now, the state has announced Lieutenant Peterson and Officer Tran. Ms. Jordan Reiser represents the state. And Ms. Reiser, you can stipulate to the issues or establish the issues you believe to be addressed.
Okay, Your Honor. Just looking at the the defense supplemental motion to suppress that was filed October 12th, 2023. And Ms. Rosenhuber, correct me if I'm wrong. It looks like there's a challenge to reasonable articulable suspicion to stop the defendant's vehicle. Prolonged detention. And a custody issue. The defense is claiming he was in custody for purposes of Miranda and he was not read his Miranda rights during the DUI investigation. Voluntariness with field sobriety evaluations, probable cause for arrest for DUI, and the reading of implied consent was not read correctly or timely. And also a Jackson Deno for voluntariness of any statements.
Prior to Officer Tran appearing, is that was the way I read the
I believe
motion?
Jackson, like just throughout the DUI investigation.
All right.
Is that correct, Ms. Rosenhuber?
Yes, that's
Okay,
correct.
did I miss anything?
You did not miss anything.
Okay. And we also, Judge, have stipulated and agreed that the video, which I'll show via Zoom, it's Officer Tran's body cam, will be admitted into evidence for purposes of this hearing.
What is the duration of the video?
Probably about 20 minutes,
Okay.
27 minutes.
And is the entire video to be displayed?
No, the whole 27 minutes,
Yeah.
yes, because it'll cover the interaction when Officer Tran gets on scene
Okay.
until the reading of implied consent.
Any ETA and Officer Peterson?
I just texted him, Judge, let me,
While we can pause on the reporting, Miss Allen, just to go to position one, Mr. Leonard Bennett appeared in court.
Morning, Your Honor.
Good morning. And Mr. Bennett, I understand that you've been appointed conflict counsel, Miss Maureen McLeod.
Thank you, man.
All right. If y'all want to step outside to confer, that would be great. Otherwise,
Judge, I'm gonna step out.
okay.
And Judge, I do believe Mr. Gill has appeared virtually. Mr. Jaylen Gil, he's position number 3.
Yeah. I'll wait till Miss Reiser comes back.
Yes, Judge.
Mr. Jaylen Gil, please start your video, but keep your audio on mute. Thank you. You might want to lower the device a little bit. Thank you. And take your cap off.
Judge, he's getting off 75, the highway or interstate
All
75.
right. In that case, we're going to take a pause on State v. Cotman and address position number 3. Are you ready, Ms. Reiser?
Yes, Your Honor.
Okay. This is position number 3 is case 21 CR 004 343F, State versus Jaylen Isaiah Gil, accused of theft by taking from March 13th, 2021. Mr. Gil, you have a right to remain silent about the underlying facts of the case. Anything you choose to say, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Sarah Rosenhuber, who is present in the courtroom today. This case was reset in order for Mr. Gil to enter the pretrial diversion program administered by the state Solicitor General's office, and he was to report either his ongoing compliance or successful completion of the program. Ms. Rosenhuber?
Yes, Judge. It's my understanding that at this time, Mr. Gill was terminated from the pretrial program. I have communicated an updated offer to him, but we haven't had an opportunity to thoroughly discuss what he wants to do today. At this time, Judge, since we do have a motion to suppress going today, I would just ask for a final plea calendar at the court's convenience.
And denied. Okay. Y'all are going to talk about the plea offer. This case was reset previously in order for these issues to come up. And I want to know why he was terminated, and I want to know what was the purpose of rescheduling this for ongoing of compliance. And if the termination was in part due to Mr. Gill, then I expected him to be in the courtroom in person,
Judge,
not via Zoom.
he would have been here, Judge, but he does attend university out of state. I believe he is,
Yeah, that's when we say we have an excuse to the school because he has to attend court. Simple as that. All right, Mr. Gill, we are going to, either your attorney's going to call you, or would you like a breakout with your laptop outside?
I can
Which one
step
would
out
you
and
like?
call him, Judge.
Okay,
Mr. Gill, will you have to sign to take a phone call on the device you're using right now? Okay, Judge, is that okay if?
that's
he pops
perfectly
out?
fine.
Okay,
Mhm.
I'm gonna step out and, well, go ahead and make sure I have your correct number.
All
Mr.
right.
Gill. Could you chat me, please?
All right, position 1 is in conference with his attorney. Position 2, we are waiting on Officer Lieutenant Peterson. And position 3, Miss Rosanova is going to be conferring with her client. So I guess this is a good time to take a recess then. All right. We'll be in a brief recess until one of the cases that I've listed is ready to be addressed. Thank you. All right, we are back on the record. So a couple announcements for the three cases that we have. Position number one, Leonard Bennett is still outside conferring with his counsel with regards to motion. Position number two, Ms. Reiser, State Department, your witnesses are now present,
Yes, they are, Judge, and we're ready to proceed.
okay? And position number three, Jaylen Gil, Ms. Rosenhuber, counsel for Mr. Gill, has indicated that Mr. Gill has decided to accept a plea offer from the state. So they are in the process of getting the documents squared away. All right, so before I move forward, Ms. Bolton, you'll let me know as soon as you get the plea documents.
Yes, Your Honor.
Has your client completed them, Ms. Rosenhuber?
The plea documents have been completed. That email is being sent right now, and he is currently working on filling out the probation contact information sheet.
Okay,
And I'll also get that to the litigation manager.
and Ms. Reiser, do you see a signed document from a signed plea document? Because since you all sent the DocuSign.
Let me see. It should, when it's signed, it should go directly also to Ms. Bolton. I put her in
I have it.
to get it. Yes, I have it. Mhm.
All right. In that case, since we have it, Ms. Bolton's going to print it up. So we're going to begin with our plea hearing. Any objections?
No objections, Judge. I believe Mr. Gill is filling out that oh, no, he is present, Judge. So we'll be prepared to go forward.
Okay. Um, This is State versus Jaylen Isaiah Gil, 21 CR 004343F. Mr. Gill is accused of theft by taking from March 13, 2021 in Fulton County, Georgia. Upon conferring with his counsel, Mr. Gill is indicated that he is willing to accept a plea offer and enter a guilty plea or a NOLO plea, I'm not certain. As soon as the state allocutes its offer, then we will be more certain. Mr. Gill, first of all, this is going to be a proceeding in which you'll need to testify in order for me to make sure that if you decide to enter a plea, that it's being done willingly, knowingly, and voluntarily. So therefore, you need to make sure that your phone device is facing you, because right now, all I can see is the ceiling and the top of your head. Then you need to unmute your device and make sure you lower it so that I can see you.
My fault. It's hard to hear. I can't really hear you right now. That's
Is your
why.
device at the top of its volume?
Yes, ma'am.
All right. Okay, if you could face me right now, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. Ms. Sarah Rosenhuber is representing you from the Public Defender's Office. For purposes of this plea, I would need to place you under oath. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, now you can put your phone close to your ear because the prosecution is going to tell me what's the plea offer. Ms. Reiser?
Okay.
Yes, Judge, the state's recommended sentence is 12 months of probation to complete a theft prevention class, to complete 40 hours of community service, and upon completion of those conditions, the probation will terminate.
And what's the nature of the plea that's being accepted by the state?
The guilty plea to count one.
So 12 months probation, 40 hours community service, and terminate upon completion of community service. All right,
That's correct, Your Honor.
to a guilty charge. All right. And Ms. Rosenhuber, does your client accept these terms? And do you stipulate to the factual basis, venue, and ID?
Yes, Judge. However, Ms. Reiser and I did discuss allowing Mr. Gill to do phone-in probation as he is a 19-year-old college student in Pennsylvania. So we would ask the court to accept the negotiated agreement with the additional condition that he be allowed to phone into probation to report.
And the state has no objection to that. We did discuss that.
All right, I'll allow phone-in probation, but we'll need to receive his completed probation form before noon today.
I'm doing.
All right, you can pause on that because we need to go through the colloquy for the plea. Mr. Gill, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And is anyone forcing you or inducing you to take a guilty plea today?
No, ma'am.
Are you satisfied with your attorney services?
Yes, ma'am.
And has it been explained to you that if you decide to plead guilty to this charge, this misdemeanor offense of theft by taking, that
Yes, ma'am.
you would have to give up your constitutional right to have a trial in front of a judge or a jury, to be able to challenge the evidence and the witnesses brought before you, to confront your accuser, to present any defenses or mitigating evidence if you choose to do so, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by taking?
Guilty.
Your sentence is going to be 12 months probation. Your first phone-in report will be next Thursday before 3 p.m. to the probation office, at which point then you will be assigned a probation officer. You will then continue to report every month. You'll be
Okay.
required to pay probation fees for every month that you are on active probation. While you're on active probation, you would need to complete 40 hours of voluntary community service, and that must be done at any nonprofit agency. Remember, a nonprofit agency has a tax code designation of 501c. You can do your community service at any of these type of nonprofit agencies as long as it's not a school and not a church. Understood?
You said I can't do it at a school?
You cannot do it at any educational institution, and you cannot do it at any religious organization.
Okay.
You can do it at Goodwill, at Salvation Army, those kind of places. But other than those two exceptions, you have a whole range of 501c corporations. Now, when you complete the 40 hours of community service, the completion must be evidenced by a letter issued by the nonprofit agency. It must be on a document with the company's letterhead and signed off by the supervisor. We do not accept emails. We do not accept handwritten documents. It needs to be a formal letter. Do you understand?
Yes, ma'am.
All right. As I said, you will report to probation next Thursday before 3 p.m. by phone. You will be allowed to do your phone-in reports. You need to make sure that your phone number is current with the probation office at all times.
Okay.
And your probation fees will be due as invoiced by the probation office. Your probation will terminate once probation receives the letter from the nonprofit agency indicating that you have completed your 40 hours. And once probation is satisfied with the letter, then your probation will terminate.
All right.
Sooner you're done, the better it'll be for you. Thank
Okay.
you.
Thank you.
Make sure you email the probation document to your attorney, and Ms. Rosen will make sure Ms. Bolton gets it.
I certainly will, Judge.
And-
Thank you so
and
much.
We'll need to make sure he has his correct phone number. All right, Mr. Jaylen, you're free to go.
Okay.
Clarify, he can call the number that's at the top of that probation document to phone, correct? Okay.
All right, we're gonna move on to position number 2, State v. Thomas Cotman. Both the witnesses are present in the courtroom for the state. Miss, are we invoking the rule of supervision?
Yeah, we will,
are,
Judge.
If I could step out to get my client.
Oh, okay.
Officer Tran, do you want to step out? Because we've invoked the rule of sequestration. So just hang out in the hall for us before your testimony.
Yeah, we have to.
It's unlocked.
Yeah, there's a screen outside, but I believe the audio is off and there's no closed captioning, so
Okay.
they may be able to see you, but they won't be able to hear. All right, Ms. Bolton, here you go. All right, we are here on State v. Cartman, 21 CR 007316F on the defense's motion to suppress. Opening statements, please.
Judge, I'll review, I don't have any opening statements. I'll just reserve for closing argument.
Okay, Ms. Hoover, sorry, Ms. Rosen Hoover, so.
Yes, Judge. We are moving to suppress all of the evidence and statements recovered in this DUI investigation. Mr. Cotman was under arrest and in custody long before the state is contending that he was. And at that time that he was actually placed under arrest, there was no probable cause to do so. Further, Judge, if the court agrees that Mr. Cotman was actually arrested when the state contends he was, the detention was still unlawful because that detention was prolonged and the actions that he did were involuntarily performed. Further, Judge will also argue that since the implied consent notice was read too late, the breath test must be excluded as well. And I do have copies of law for the court with a general outline of the cases or the issues, if I may hand that to the judge, to your honor at this time.
All right. Thank you. And what we have right now is a podium, right? We have a court reporter who's on Zoom. We have a podium there where the witness can either remain standing or he can be seated with the microphone repositioned so that he can be heard. How would the state like to address that?
Judge, we'll just have Lieutenant Peterson come to the podium. Right there.
All right.
Lieutenant Peterson, you just want to stand at the podium right there for me.
Could you just do a test on the audio? Testing 1, 2, 3.
Just do 1, 2. Oh, it works.
Wonderful, it's so good. And Lieutenant, would you like a chair right there and we can reposition the microphone so that you can speak?
I'm good.
You good?
Yes.
All right, just let us know if you want to be seated.
Thank you.
Okay, it's just because of the pandemic, wiring of the courtroom has become very unorthodox.
Understand.
All right.
And Your Honor, may I have permission to remain seated to the microphone?
All right, do you have Bob? Would you like to
Oh, yeah.
swear in the witness?
You swear or affirm testimony you're about to give, the matter before the court, the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir.
Thank you. Lieutenant, can you state and spell your first and last name for the record?
Sure. Robert Peterson. Robert is ROBERT. Peterson is PETERSEN.
Thank you. How are you currently employed?
Atlanta Police Department.
And what is your position with Atlanta Police Department?
Lieutenant.
Okay. And in that role as lieutenant, what sector are you assigned to?
Currently at the airport.
Okay. And what do you do at the airport?
I'm the watch commander for day watch.
Okay. And what are your typical duties and responsibilities?
At the airport?
Yes, in that role.
Making sure that that pretty much making sure that everything runs smooth in the watch, making sure the supervisors have what they need, officers have what they need, they're doing what they're supposed to do, be what they're supposed to be, and also admin duties and meetings and different things like that.
Okay. And prior to your position at the airport, were you in any other positions or sectors at APD?
Yes.
And what were those?
From beginning to end, or?
Just generally, yeah. So all the positions you've held at APD.
Okay. So I was an officer.
Uh-huh.
I was a detective. I was a sergeant. I'm now a lieutenant. I was a hostage negotiator. I was the commander of the hostage negotiator unit. What else do you want to know?
Here's you're the jack of all trades in the APD. So that's good. How many total years have you been in law enforcement?
31 and a half.
And are you post certified?
I am.
Okay. And I want to bring your attention to February 28th, 2019. Were you employed with APD at that time?
I was.
Okay. And were you working on duty or off duty that evening or early morning?
Off duty.
And can you tell the court a little bit about what your off duty job was on February 28th, 2019?
I was working an extra job on the movie set of the movies Bad Boys 3.
Okay, and when you say you were working an off-duty job at Bad Boys 3, so what was your responsibilities during that employment, off-duty?
On that particular night, I was the lead supervisor. And what they were filming a very a dangerous scene, a helicopter scene with pyrotechnics. So we had the streets blocked off, and just making sure that everybody was in place from APD, and making sure that the areas leading to the area was properly blocked off and secured, so no one could access it while they were filming.
Okay, and you said that it was a very dangerous scene, and what made it so dangerous about that scene that you all had to block it off?
It was a helicopter scene, and there was a lot of pyrotechnics explosions going off.
Okay,
Yes.
and so the area surrounding the helicopter explosion movie set scene, was that barricaded by signs?
Yes.
Okay,
Mhm.
was it barricaded by police cars as well?
I can't remember if we had a patrol vehicle out there. I think SPO Mitchell from DeKalb had his vehicle out there. But
Okay.
there was definitely barricades, there definitely officers, there was definitely PAs, which are production assistants with the reflective vests that was out there also.
Okay, and while you were working your off-duty during that movie set, did you come into contact with a person or defendant driver, Thomas Cotman?
Yes.
Okay, and can you tell the court what you observed about, well, I'll say, what did you observe when you were working your movie set? What happened?
Mr. Cartman initially came west on 17th Street. We directed him to go south. About 5 minutes later, he came back and made the left going back west and drove through the barricades. There were people trying to flag him down, waving at him, yelling at him, and he drove through. I believe it was 2 barricades, and he drove through the space in between the 2 barricades before myself and SPO Mitchell managed to get him stopped.
Okay, and so when you say drove through the barricades, like went all the way through, like into the movie set?
Yes.
Okay, and did his vehicle eventually stop?
Yes,
Okay, and did you and Officer Mitchell make contact with him?
we did.
And what did you observe, if anything, about his demeanor when you made contact with him?
Well, we opened the door because we wanted to know, hey, didn't you see the signs? And we immediately smelled alcohol.
Okay,
And he appeared to be under the influence of something. We weren't sure at the time what. Slurred speech, kind of slow to answer. At that point,
Mhm.
we suspected he was under the influence of something.
Mhm.
And at that point, we detained him and we called for a Zone 5 unit to come to respond to the scene to deal with the incident.
Okay, and when you say you detained him, what do you mean detained him?
We removed him from the car and we placed handcuffs on him.
And why did you make a decision to place handcuffs on him?
Because we wanted to detain him for the investigation. And so we went ahead and we detained him for his safety as well as ours.
Okay, and when you detained him, where did you place him? Like set him down at?
I can't remember if we sat him on the curb or if we stood him up by his on the curb. I can't remember where we
He wasn't in the back of a police car?
not that I remember until Officer Tran came.
Okay, and did you ever tell the defendant at any time he was under arrest?
No,
Okay, and why was Officer Tran flagged down?
because he was on duty working Zone 5. We were working the movie set, and for a situation like that, we usually call a zone unit to handle anything outside of the movie sets.
Okay, and did, how quickly, if you could estimate, if you recall, how quickly was Officer Tran on scene?
To be honest with you, I can't remember how long, but it wasn't a very long time.
Okay. And also, when you guys made contact with the defendant, I know you just testified that you smelled the odor of alcohol.
Right.
Did you observe anything inside the car?
Yeah, as we were approaching, he reached behind his seat and was sticking something under the seat. That's another reason why we removed him from the vehicle. When we looked in, we saw like an open container.
Okay. Okay. And when Officer Tran arrived to do a further investigation, was the defendant removed from his handcuffs? If you can
Yes.
recall?
Yes, because he had to take him through the field sobriety test.
Okay, thank you. No further questions at this time, Your Honor.
All right, Ms. Rosenberg, your witness for cross.
Yes, Judge. Good morning, Lieutenant Peterson.
Good morning.
I apologize for the awkwardness of this, but forgive me. You said on direct that you called specifically Zone 5?
Yes.
Okay, but you actually called for a heat unit, right?
I can't remember if it was a heat unit or zone 4, but I did call for a unit. I thought we were in zone 5. I normally would call a zone 5. Now, it is possible that we did call a heat unit because heat units normally handle DUIs and stuff like that. So I can't remember specifically who I called.
Right.
So if I said zone 5, then okay, I was wrong. But I remember do call it for a unit. Yes.
Okay, but specifically, you were calling for an officer who would make a DUI arrest.
Well, he was under the suspicion of DUI, and normally, again, we will call for a specific DUI unit, but any unit that's been trained can do it. But yes, ma'am.
Okay. You also said on direct that it was Sergeant Mitchell who stopped Mr. Cotman's vehicle.
It was both of us. I believe it was both of us.
It was both of you.
Yeah, because we were together right there at the when he came through. If I remember correctly, when he came through the second time, we were standing there. We were like, hey, and that's when we ran up to the vehicle. I can't remember the specifics, but we did stop his vehicle. It was one of us. We did stop the vehicle.
Okay. And do you remember speaking with Officer Tran when he arrived on scene?
Yes.
And do you remember telling him that it was not you who stopped the vehicle?
I don't remember the conversation with him.
Would you be able to recognize your own statements on Officer Tran's body camera footage?
Yes, of course.
Okay. Judge, if I could have a moment to, I know that this exhibit has not been admitted into evidence yet, but I may need a moment to pull up the video for impeachment purposes.
All right.
I have it pulled up, Sarah.
Okay.
Um,
Could I give you a comment?
Are we doing a screen share of the video?
yes, please, Judge, if we could share screen.
And all right, and this is the state's exhibit. Ms. Rosenhuber, did you want to use your own? Then you can do a screen share, or would you like Ms. Reiser to direct the video to whatever time spot?
For right now, Judge, this is perfect if Ms. Reiser doesn't mind. If we could just, and this exhibit, we don't object to its admissibility. If we could go to timestamp of about 3 minutes in, please. And Lieutenant Peterson, if you could just review about 15 seconds of this, and we'll pause and I'll ask you a few more questions, okay? Do you have the ability to see? Oh, you can see it up there.
All right, and we're going to call this State Exhibit 1, Ms. Reiser?
That's fine, Your Honor. Yeah.
All right.
You told him to deter traffic once, and then he came back. And then you guys.
He didn't hit anything.
He didn't hit anything. He just blew through.
Everybody jumped out of the way.
Were there any who was the first one that walked up to his vehicle?
I'd been Lieutenant.
Because let me see if I could, I mean, we're not supposed to search, but
Mm-hmm.
Lieutenant Peterson, I know it was difficult to hear, but were you able to hear your response?
No, what did I say? No, for real.
No, I know.
I was trying to.
Perhaps there's a better timestamp of it, but I heard the name of a Lieutenant Watts.
Watts. Okay, and what about Lieutenant Watts?
I'm asking you, do you know who that person is?
There may have been a Lieutenant Watts working because like I said, it's APD, and then there are other so there may have been a Lieutenant Watts there.
Okay, let's go to timestamp. What timestamp are we at right now?
3:30.
Okay, if we could back up to 2:55, please. And I know the audio is difficult to hear.
Were there any who was the first one that walked up to his vehicle?
I've been lieutenant once.
Because let me see if I could, I mean, we're not supposed to search, but if we see anything.
Search incident to arrest for any. You can do that, or you can search for the driver's reefs.
Yeah, but I was thinking maybe he have like a bottle in those bags right there.
Bro,
That-
you can smell it, yeah.
Smell?
So once that happened, I was on the other side, and then he called me. I'm sorry.
If you could
I'm
pause
Lieutenant Peterson, by the way.
Okay, Lieutenant Peterson,
Yes.
am I correct in hearing that you said to Officer Tran that you were on the other side of the movie set and then you got a call to come over there?
Right.
Okay,
Mhm.
and I just want to confirm, is that what happened? Is that what you remember?
When I said the other side, I don't mean the other side of the movie. Okay, so you have, this was one side, this is one side, okay? Then you had, this is where they were filming, and then this is the street, okay? So when I said I was on the other side, I don't mean that I was on the other side of the movie set. When I said I was on the other side, I meant other side over here. Okay, but I did see, because I did see when he come down and he made the left, and then he came back out. No, I said that I was one of the ones that stopped him. Maybe I did. I cannot again. It's been 2019. Okay, since it happened. All right. So I'm not trying to be deceptive. Because I work at a movie set, but I do remember specifically this incident. But go ahead.
Sure. So just to be clear, it has been several years,
Right.
right? And you've admitted it may be difficult to remember specific instances.
Right.
You'd agree with me that maybe what you said at the time of the incident is a little bit more reliable,
Yeah, that's fair because it was fresh. Yes.
right? Because if you said at the time that you weren't the one who stopped the vehicle, that would probably be a more reliable
Right, yes,
statement of
yes, ma'am.
fact. Okay, I'm just making sure. You never wrote a report in this case.
I did
you?
not. Mm-mm.
Okay, but you did advise Officer Tran about what you were able to observe
Right.
and what you learned from other officers.
Right.
And by the time that Officer Tran arrived, you said Mr. Cotman was already handcuffed
I believe so. Yes.
and he was sitting on a curb.
I believe so. I can't remember specifically where he was sitting.
Sure, well, if we can look at the video since it's up, can you see him on the screen?
So yeah. Good. Since I'm ABD, he called me. Yeah.
Yeah, it's in there.
Yeah. But I mean, you can smart it on him.
Are you able to see him, Lieutenant Peterson?
Right there.
Hey, but if
Just point him out. He's.
You sitting in the car?
Mm-mm.
Can you see him? I apologize. Is it fair to say that this is Mr. Cotman?
Okay, that's it. Okay.
Okay, and he's sitting on the curb.
Right.
Okay. I don't have any further questions for you. Thanks for your time.
Any redirect? And can we pause the screen share?
Oh, yes, Judge. I can pause it. Sure. Just to reconfirm, Lieutenant Peterson, you did in fact see Mr. Hotman drive through the barricade,
Yes.
and you did in fact observe an odor of alcohol on
Yes.
his person,
Yes.
and you did in fact observe open containers in his vehicle.
I did.
No further questions.
All right. May I release Lieutenant Peterson or do I need to keep him available? State says doesn't need him. What was the defense?
I don't need him, Judge.
Right. Lieutenant Peterson, I appreciate you making the drive here and you have a safe day. Thank you. Free to go.
Thank
They
you.
may call their next witness. Would that be Officer Tran?
Yes, Your Honor.
Lieutenant, if you could just summon Officer Tran, he should be seated out there. Thank you.
I can't hear you. Oh. Officer Tran, you can go up to the podium right there. That's where you'll be.
Yes, please.
Officer Kern, would you rather be seated or would you rather stand?
Standing is fine.
Okay, very good. Please, for the rest of you sworn, do you swear or affirm the testimony you're about to give, the matter before the court, be the truth, the whole truth, and nothing but the truth, so help you God, or so affirm?
Yes.
Thank you. Officer Tran, if you can state and spell your first and last name for the record, please.
First name is Son, S-O-N. Last name is Tran, T-R-A-N.
And Officer Tran, how are you currently employed?
I'm currently employed with Georgia Tech Police,
And what's your current position with Georgia Tech Police?
police officer,
And what are your duties and responsibilities in that role?
patrolling around the Georgia Tech campus.
Okay. And prior to your position with Georgia Tech Police, were you employed with any other agencies?
Yes, with the Atlanta Police Department.
And when you were employed with Atlanta Police Department, what was your role or position there?
I was in Zone 5 as a patrolman, and then right before I leave, I got promoted to senior patrolman.
Okay. And what were your duties when you were a patrolman or a senior patrolman with APD?
Answering 911 calls and anything that comes up, anything that extra jobs officers need.
Okay. And are you post certified?
Yes, I am.
Were you post certified back in 2019?
Yes.
Okay. And in terms of your training within your employment, have you had any DUI training?
In the APD Academy, I had 40 hours of training. I am not SFST, but I know how to do walk and turn
Mhm.
and one leg stand. I've done numerous of those throughout my career.
Okay. And have you ever, before February 28th, 2019, and I guess subsequent to that date, have you ever conducted a DUI investigation?
Yes.
Okay. Approximately how many, if you could put a number on it?
Anywhere early on in my career, maybe 10 to 20.
Okay. And on February 28th, 2019, were you working in your employment as an APD patrolman?
Yes.
Okay. And were you called out to the intersection of 17th Street and Village Street?
Yes.
And why were you called out to that location?
Lieutenant Peterson, he was working an off-duty extra job, and he came over to Zone 5 radio requesting assistance because he said that somebody just ran through his movie production site through the barricade and he needed additional assistance.
Okay. And did you respond?
Yes, I did.
And approximately how quickly did you get there when it came out over the radio, if you can recall?
I'm pretty sure I responded pretty timely within, I'm not sure, but at that time,
Would you say like within minutes?
yeah.
Okay. And when you got to the location, did you make contact with Lieutenant Peterson and Officer Mitchell?
Yes.
Okay. And what did they advise you when you got on scene and spoke with them?
They told me that they were working on set for a movie production. There was some type of action sequence, and they said an individual just drove through the barricade. And so they made approach and they try to detain the individual for officer safeties and whatnot and try to figure out what was going on. And they told me that he's possibly under the influence of alcohol. And he said that there was an open container in the back seat. And he, basically give me some additional information before I start my SFST.
Okay. And When you made contact, or let me back up. When you were talking with Officer Mitchell and Lieutenant Peterson, was the defendant detained at that time?
Yeah, he was detained.
Okay, and when you say detained, was he in handcuffs?
He was.
Okay, and what did you ask Officer Mitchell, excuse me, yes, Officer Mitchell and Lieutenant Peterson, if they ever told him he was under arrest?
Yeah, I asked them if he was in custody. They said no. They detained him for safety reason, for the sheer fact that he just drove through barricade and whatnot.
Okay. And when did you eventually make contact with the defendant?
Yes, I did.
And when you made contact with the defendant, did you remove his handcuffs, or was his handcuffs removed?
I did.
Object to some meeting. There's a little bit of meeting.
Sustained.
And when you made contact with the defendant, what did you do?
Yeah, once I made contact with the defendant, once I got, the lieutenant's side of the story, that's when I conducted my investigation. Of course, the scene is safe. Once I feel the scene is safe, I remove his handcuff for the investigation.
Okay. And when you made contact, did you observe anything about the defendant?
Yeah, his physical manifestation shows that of people in the past that I've encountered are under the influence of alcoholic beverages.
Okay. And what observations, if any, did you observe of the defendant?
Strong odor of alcoholic beverages, watery eyes, and I'm sure there's additional in my police report as well.
Okay. And did you ask the defendant where he was coming from?
I did.
And what was his response?
He said he gave me a couple of stories, but the one that I went with is that he said he's coming from a friend's house.
Okay. And did you ask him if he had anything to drink?
I did.
And what was his response?
He said that he had about a beer
Mhm.
30 minutes prior to running through the barricade. And I even asked him stuff that I asked everybody on my investigation on a scale from 1 to 10. How intoxicated are you, with 1 being sober and 10 being the most you've ever been intoxicated? At the time, he said he was at a 3.
Okay. And based on all those observations, did you ask the defendant to perform field sobriety evaluations?
I did.
And what was his response when you asked that question?
He consented to it.
Okay. And at any point when you asked him to do field sobriety evaluations,
Judge, this is starting to sound like more of a leading question again. I'll just renew my objection.
Judge, I'm establishing the voluntariness of fields. I
All
need
right.
to, I'm
So
not leading.
I am going to sustain in part. If you want to advise the witness that you are now going to discuss field sobriety tests, then you can begin your question with who, what, where, why. But asking him, did you conduct field sobriety tests? That's a leading question.
Okay. Okay, so well, he just testified that he conducted field sobriety tests. And when you said you testified that he consented to field sobriety test, what type of field sobriety test did you ask him to do?
So because I'm not certified for HGN, I only requested for the walk and turn and then going into the 1-leg stand.
Okay, and I want to talk about the walk and turn first. Did you medically clear him?
I did. I always start with the same statement. I ask, hey, are you able to stand for X amount of time? Are you able to stand on 1 leg? Either you're choosing for X amount of time. Were you in like any accident, head injury, stuff like that? Pretty standard stuff that I always say.
And what was the defendant's response to those questions?
He said he was fine. And I asked him, you understand the instructions and the questions that I asked you? He said yes.
Okay. And how did you explain the instructions to him?
Objection leading.
Judge, I have to get through.
I'll allow that for some, if you're trying to establish some foundation,
Yeah, it's
but
foundation for walk and turn.
go ahead. Overrule.
And what, did you give him any instructions on the walk and turn evaluation?
Yes, I always start, of course, with SFST, you start with the instructional phase, make sure that he doesn't, show any clues in the beginning.
Okay. And can you explain to the court how you instructed him and what you instructed him to do?
Yeah, so I, always tell people with the walk and turn, make sure you have your hands by your side. We're gonna get into the starting position. And then, whenever you're ready, just place your left foot and then have your right foot over your left foot in a heel to toe manner. And then, don't start until I tell you to do so. And then I'll give him the instruction and then tell him I'm going to demonstrate. So I'll tell him, when I tell you to start, you can do 9 heel to toe steps. Okay. And once you get to the 9th step, you're going to take a small series of steps to turn around and do 9 more steps back. And then while I'm doing that, I also demonstrate, saying that I'll demonstrate 3 steps, do the small series of steps, then I'll do 3 steps back to look for his level of concentration, if he's able to comprehend what I'm saying, understand instructions. Those are all the stuff that I learned through HD Academy for the DUI.
Okay. And can you describe the defendant's performance on the walk and turn evaluation?
Based on my report, he did emit or he showed 4 clues. And
if you looked at a copy of your report, would that help you refresh your recollection on the clues that you observed?
yes. Yep.
And just read over that report, read over your report and let me know when you're done.
Yep. Give me a second. I'm ready.
Okay. And I'll re-ask the question. What clues did you observe, if any, from the defendant's performance?
So based on my report, I'm not going to read it verbatim. I'm just going to, say, based on the report, he broke heel to toe. He did not perform the correct number of steps. He broke off line and he did the incorrect turn.
Okay. And what did you do after the the walk and turn evaluation?
So once he, performed the walk and turn, I transitioned over to the instructional phase of the 1-leg stand.
Okay. And can you explain to the court how you instructed the defendant and what that typically looks like?
Yep. So I'll tell them to go back to the same point and tell them, have both feet together, hand by your side, and, don't move until I tell you so. And don't start until I tell you to do so. And then I'll ask them, hey, you understand everything so far? And then when I tell them, when I get a confirmation, okay, when I tell you to start on the 1-leg stand, you can choose of your liking. And I'll tell them, for this demonstration, I'm gonna use, my left leg or my right leg. And then I'll tell you, once I tell you to start, you're going to have your legs raised at least 6 inches off the ground. Tell you to hold it for 30 seconds. And then you're going to count out loud 1001, 1002, 1003 until I tell you to stop. And that's, I ask them again, do you understand the instructions that I've given you so far? And, with his confirmation, that's when we proceed into the actual performance.
Okay. And when you say with his confirmation, what do you mean by that?
That he's clear of my instruction.
Okay. And did the defendant perform the 1-leg stand that evening or that morning?
He did.
Okay. And can you tell the court what the observations you observed?
based on the report,
Mhm.
I'm not gonna read it verbatim. I did observe one clue and that he lost balance while doing the one leg stand.
Okay. And at any point during your interaction with the defendant doing the field sobriety evaluations, did you threaten him in any way?
No,
Did you coerce him in any way to perform field sobrieties?
no,
Did you give him any promises of leniency that if he did field sobrieties, then maybe it'd be better for him?
no.
Judge, these are leading
Right.
questions.
I understand.
Okay,
I understand the question, the answers you're trying to elicit, Ms. Reiser, but you would need to do it in a non-leading manner. Objection sustained.
and after your field sobriety evaluation, what did you do?
So after my field evaluation, based on the observation that I've made on scene and based on the information provided to me, of course, by Lieutenant Peterson's, I deemed that the defendant was under the influence of alcohol, less safe at the time. I immediately placed him into handcuff to have him in custody. And shortly after, I read him implied consent for breath.
Okay, and I want to back up a little bit. So you said I think you just testified that you determined he was under the influence. When you say you placed him under arrest, what do you mean?
I placed him in physical restraint. I made sure that the locking mechanism is double locked and secured to the rear. And, and I'm pretty sure I even tell them, hey, listen, you're under arrest. That's common practice. I'm not sure if I did it that night, but I'm pretty sure.
Okay, and I'm gonna show you. And I'm sorry, you just testified that after arrest, did you read him? What did you do after you arrested him?
After I place him in handcuff and have him in custody, I read him the implied consent for people over the ages of 21.
Okay, and I'm gonna show you, if I can share my screen. Well, Sarah, I'm gonna show you and see if you have any objection to it. It's the implied consent card. Do you admit it? Do we stipulate? that you admit? Okay. Judge, for purposes of this hearing, we'll mark this as State's Exhibit 2. This is the implied consent card.
Noted?
Okay, let me just share. And Officer Tran, do you see what's on the screen?
Yeah, I actually still have the card.
Okay.
Yeah, it's the same card I got.
Okay. And is this State's Exhibit, I think it's marked as State's 2, Judge. State's Exhibit 2, is this the implied consent card you read that evening?
Yes.
Okay. And did you read the card verbatim?
Yes.
What test did you ask the defendant to consent to?
For the breath sample.
Okay. And what was his response?
He stated yes.
Okay. And what did you also have body cam on that evening?
Yes.
Okay. And was it recording properly?
Yes.
Judge, at this time, I'm gonna play the Officer Trans, it's State's Exhibit 1, his body camera.
And is this going to be the 27-minute?
Yes,
Good.
Judge.
All right.
Yes.
Officer Tran, you're free to have a seat at the bench behind you while I believe this Exhibit 1 has been stipulated and its mission is and the defense has no objection to its admission. Would that be correct?
That's correct, Judge. I would just ask that we figure out how to make the audio as clear as possible, because I know earlier it was a little bit difficult to hear.
I have it
but-
as loud as it can go
Okay.
on mine.
Is there a way if the screen is shared, if
You can see it on your laptop?
I can see it, Judge? I'm more concerned about the audio. That's all.
That's, if you can, that's the best we got right now.
Okay,
So
that's fine.
unless y'all want to step outside and watch it on your own, on your own laptop. Okay, we've started the playing of exhibit. Officer Tran, you can reposition yourself if you're too far away. We have the chair right there also. If you want to go closer to the video.
Okay.
If you could come closer right there. Ms. Reiser, I think there's a chair right here.
Here, I
So
can,
they got GSP, the Hawk unit.
here, I'll give you
No,
this.
no, the APD unit that works overnight. It used to be,
If it's for DUI, I think it's called the ACE unit.
the ACE unit, yeah.
Yeah.
Are they still working, do they still work overnight?
That I actually don't know.
Okay.
So,
Take a walk up, yeah. What happened was, he's the cab, they're working right here. Because we're all working the movie set.
okay,
Apparently, he blew through.
okay.
Everybody was like, hey, stop. You know what I'm saying? But he, and so when he pulled over, yeah, he's DUI. You can spell it on him.
Okay, who's the one that pulled him over?
The flag right here. Come on, take a walk with me.
And so basically, okay.
Right.
I gotcha. Okay, let me go figure it out because if it's gonna be a DUI case on me, I want to make sure everything's correct.
Yeah, that's what.
Yeah.
Let's talk to MPO Mitchell. Yeah, this
Hey.
officer trying. Yeah.
This is what he did. I mentioned.
Morning.
This is what he did. We got all the cones, we blocked that off on this side, and then we got the street closed barriers over here. He put it one time already. We redirected it, but then he comes back to it, gets a running start, guns it, blows through the cones, and with about the security officers and then the police officers are here working. Goes to them with all the screaming and trying to get him stopped, and he blows through these barrier closed signs and goes up and tears the stunt cars before we finally get him stopped.
So you told him to deter traffic once,
Yeah,
and then he
circled
came back,
around and decided this time he drove by.
and then you guys.
He didn't hit anything.
He didn't hit anything. He
Everybody
just
jumped out of the way.
blew
Yeah,
through.
Everybody jumped out of the way.
Were there any who was the first one that walked up to his vehicle?
I'd have been lieutenant once.
Because let me see if I could, I mean, we're not supposed to search, but if we see anything.
Search incident to arrest with any. And to do that, or you can search within driver's reach.
Yeah, but I was thinking maybe he have like a bottle in those bags right there.
Bro,
That-
you can spell it. Yeah.
smell?
So once that happened, I was on the other side, and then he called me. I'm sorry. I'm Lieutenant Peterson, by the way. Yeah.
Nice to meet you.
So yeah, he called. Since I'm ABD, he called me. Yeah.
Yeah, it's in there.
Yeah. But I mean, you can spell it on him.
I don't think it's just alcohol. I think it's narcotics as well.
Hey, but if least I could do is DUI less safe and reckless driving and
Yeah.
let's see what else. So he didn't hit anything, did
No,
he?
he
Just
went-
blew through.
Right. And the signs was just wide enough for his little car to go in between it. Those road closed, blocked off.
Huh.
Just wide enough for him to be able to.
Hey LT, quick question.
Yes, sir.
Just one minor question.
Right.
So we got reckless driving, DUI less safe, obstruction.
Once he got up there, he stopped. We
Right.
from
Yeah.
from that point on. He
Okay.
didn't see any hard
I mean,
times.
if anything, fail into a traffic control device because you had
He
the
didn't have
signs.
his license on him.
Yeah. He don't
Okay.
have
He
his
didn't,
license on
no
him.
license on him, so
Yeah.
that's a violation as well.
Okay.
I got the.
Do we have any of his information?
No,
Yeah.
all
Nothing.
we got from came
It's-
back from radio.
Yeah, from ACIC, right. What I doing with my pass?
Pad, you put it in your coat pocket.
Is this even his vehicle?
Yeah.
It came
Oh,
from
Yeah.
New Jersey.
Yeah, he's legit.
Oh, okay. It's just he.
Yeah.
Okay.
I thought you put it in your pocket right here. No?
Let me
Yeah.
let me get my big notepad.
Okay.
Valid driver's license, 20B, yeah.
Is it okay if I just go ahead and just rip
Yeah,
and get the whole thing?
if you can understand my chicken scratch, sure.
I gotcha. Appreciate it.
Yeah,
And also, man, and you're the first one that saw him?
Well,
Yeah, let me, cause I wanna,
as the witness.
yeah,
Yeah.
I just wanna make sure everything is correct and, you know.
You have an impound slip? I'll start it.
Yeah, I do.
Do we still do those?
Yeah.
Okay.
We still do.
All right, okay.
So they probably do it on a computer now. I don't
You know what
know.
I'm saying?
See, that's my thing. I was on paperwork, and then everything transferred over to the computer. I'm like, okay,
Let me-
paper. It's on a computer now. I said, oh, well, okay. I'll see y'all later. I'm out.
Well, you know, I just left zone 2, so you know, but between now and then, ain't no telling. You know what I'm saying?
Let me go ahead and get a tow truck come
Yeah,
here
and
and then,
then
I'll give you the impound slip.
1505, go to Cabela. Region 1551. 93, I think it's coded,
1504 radio.
Region 04, go ahead.
1504, could you go ahead and start an 85 mile location for one vehicle? And just as advised, ATO, go on 14th Street and then go on to Village Street, and they'll allow him through. They're currently blocking off for the movie set.
Okay, 14th and Village. Okay.
That's correct. We're on 17th and Village, but he'll be able to access it through 14th Street.
Okay, okay. Region 1515.
Oh,
30 years.
Yeah.
It'll be 30 December. Right now it's 29, almost got 30.
My 27 will be April.
May I get your information?
S.J. Mitchell,
SJ.
badge 296,
You said
KPD
2986.
2096.
Oh, okay.
2096.
Okay.
DKPD
Okay, appreciate it.
1960 West Exchange Place,
You said
Tucker,
West Exchange?
Tucker, Georgia. 30032, I think.
30032. Okay. Okay. And he was right at 17th and Village?
So what's the zip for 1960 West Exchange Place? You didn't get out.
Hey, LT. May I get your information, please?
Oh, definitely. I'll write down for you.
Oh, okay. Perfect.
Who's the morning watch lieutenant now?
Right now it's gonna be Lieutenant. It's hard to. Broninger?
Roninger, okay.
Yeah.
He just made it.
Yeah, he did.
Who's your sergeant?
We have Sergeant Busby, Sergeant Kleinhens,
Kyle, yeah.
Kleinhens,
Uh-huh.
Sergeant. I think Bartholomew. He's kind of
Okay,
like part-time
Okay.
in Zone 5, Zone 3,
Okay.
and then we have Sergeant Brotnick. Hey, could you? You know what?
Yeah, County PD.
You want my address on here too? You need the address on here too?
1 second.
For me.
Yeah. This,
1519, go ahead.
Talk to me. What you need?
hey, LT. Let me. Just
1529, I copy. Last 40328,
So-
0328.
Here's how you
like normally,
Mhm.
I'm all for doing DUI,
Right.
but the only issue is he's already in cuff.
Okay. Yeah.
I can't really do my whole spiel of.
We can take
But-
it off.
I mean, I could do it, 17 and everything, but it's just that he's already in cuff. It's hard for me to like. I could do the charges.
30084.
Oh, okay, 30084. Copy. I mean, I can do it, but it's just just procedural wise, it's like I can't ask him the standard DUI question that I normally ask.
Why not? Because he's in cuffs.
Right.
He's not under arrest. He's being detained right now. So you can still ask him.
And we can unhandcuff him
Right.
if you want to do a close body or.
Right.
We did that for his own safety.
So you,
Right,
okay, so
yeah.
you guys, nobody said
No.
anything about
Mm-mm.
custody, none of that?
Nope.
No.
Okay,
Uh-uh.
okay,
We're in the middle of a Bad Boys 3 movie scene with all
Yeah.
the stunt drivers.
Right.
For his safety, we didn't want him, for intoxicated purposes, to fall out and get hurt or fall in front of one of the cars. We
Right.
shut everything down until you got here
okay,
for his safety only.
okay, we'll work with that.
Yeah.
Yep,
Okay.
okay. I just had to clear that out, make sure. Okay, I got you, appreciate it. What's your name, sir?
Thomas Cotton?
You say, Thomas Cotman?
Yes.
How you spell it?
Cottman.
Okay. All right. Now that we have my lieutenant took off the handcuffs, we're just gonna walk over to my patrol vehicle really quick, okay? And then we'll talk. We'll talk. I'll explain further, okay? All right. And then my vehicle right there. And you can just stand right in front of my vehicle, and we'll just. Yep. So right now, I'm just going to ask you a series of questions and just try to answer them to the best of your ability or your knowledge, okay? And just very quick, very simple, straightforward questions. Where were you coming from? Home. Where's home?
In Ellenwood?
Ellenwood?
Yes.
Where's Ellenwood?
Ellenwood is east of Atlanta.
Ellenwood is east of Atlanta?
Yes. 20 east.
20 east of Atlanta. Okay. And what were you doing here in Atlanta?
Visiting a friend.
Where's your friend?
My friend is in town suites.
In Town Suites?
Yes.
Where's that?
That is actually where I was trying to find my way to. My GPS was leading me that way.
I gotcha.
It's not too far from here, though. It's actually only a few minutes from here. I was only a few minutes away.
I gotcha. And you say you were coming from home and then going to see your friend?
To stay the night, yes.
Okay. Did you have anything to drink?
Yes.
I'll say about how many?
Just the one.
What kind of drink is it?
A beer.
A beer?
Yes.
Okay. Okay. A beer. You say about how long ago?
30 minutes or so, however
Well-
long it took to.
Okay. About 30 minutes. Okay. Now, is Mickey Mouse, is it a cat or a dog?
Mickey Mouse is a mouse.
Right. Now, let's say from a scale from 1 to 10, with 1 being the most sober and then 10 being the most intoxicated you've ever, meaning like just blown out intoxicated. Where do you think you are on that scale? 3?
Yes.
Okay. I gotcha. Okay. I gotcha. Okay, so right now, what we have in this situation, my lieutenant, one second. My lieutenant, there's suspected you have DUI, so basically I'm just here, just to make sure. So, I would like for you to take a standardized field sobriety test. Okay, and before we take the test, I just have to explain certain things to make sure that you are able to take it. Okay. Now, are you hurt or injured anywhere?
Well, not from anything like this, but I do have neck and shoulder
You said you have a neck and shoulder?
Yes.
Neck and shoulder injury? Okay.
Not necessarily an injury, but there's been a lot
A lot of, okay. Now, are you able to stand for maybe a duration of about 5 minutes?
Yes.
Could you do that? Are you able to walk and you know, do all that normal daily activity?
Yes.
Okay, so now, do you have any head injuries, anything like that? No head injuries? Okay. Okay, sir. Now, are you able to stand on one leg for a duration of maybe about 30 seconds?
Yes.
Okay, I gotcha. All right, sir. So we're first going to start with the standardized field sobriety test. We're going to start what we would call it the walk and turn test, okay? So with the walk and turn, I'm going to give you a quick demonstration. I'll explain to you the whole procedure, okay? And all right. So we're going to use this white line as our base, okay? All right. And with the white line as our base, we're going to have both hands to our side, okay? And remember, we're going to use our left foot as the leading foot. And we're going to do 9 heels to toe, okay? And then once you get into the 9th repetition, when I want you to turn, you have to pivot, okay? Take small pivots, okay? And then you go back with 9 heels to toe, all right? And then during that, make sure that your focus is on your feet, okay? So heel to
Making
toe,
sure that they constantly meet from heel to toe.
heel to toe, heel to toe, heel to toe, correct? All right. And if you could just get on the line and then just on me, okay? All right, go ahead.
Just the 9 straight forward.
Just do what I showed you earlier. All right. Yep. Yeah, you can go ahead. Just like how I showed you. All right, sir. And just over here. So the next one is the one where you can choose whichever foot you want to use as your base, okay? And you lift it at least at minimal 6 inch off the ground, okay? All right, and you
Now,
keep
I'm sorry, help me. How high would that be?
6
About
inch.
6 inches off the.
Yep. So just standards, whichever you could use either your right as the base or your left, just 6 inch off the ground, okay? And then just count out loud: 1,000, 1,000, 1,000, 1,000, until whenever I tell you to stop, okay? All right, on me. Go ahead.
1,000, 2,000, 3,000, 4,000, 5,000, 5 1,000, 6 1,000, 7 1,000, 8 1,000, 9 1,000, 10 1,000, 11 1,000, 12 1,000, 13 1,000, 14 1,000, 15 1,000, 16 1,000, 17 1,000, 18 1,000, 19 1,000, 20 1,000, 21 1,000, 22 1,000, 23 1,000, 24 1,000, 25 1,000, 26 1,000, 27 1,000, 28 1,000, 29 1,000, 30 1,000.
All right, you're good. All right, sir, just go ahead and put your hand behind your back, okay? Here, I got you. All right, sir. Just follow me. All right, based on the tests and all that I've gathered, I believe that at this point in time, you are currently, when you were operating that vehicle, you were, under the influence, okay? You have anything sharp on you that may stick, stab, or poke me?
I do not.
You do not?
May I ask?
All right, sir. There you go. What's up, LT? No. Open container. No.
Yeah. Because he saw him reaching up under the seat.
I didn't know what he was reaching back for. That's why I was really concerned.
Yeah. And I didn't know that until just now when I looked.
I was telling you how he was reaching around inside.
Right.
That's what he was doing.
Then I came and I started looking, and there it is right there.
See, I knew it was the black bag, and
Right.
I'm like, I knew.
He tried to hide it up under the seat. And if you smell his breath, it's not beer. It's something fruity. Yeah. So yeah.
Smell the beverage from it, but not
Right.
the alcohol is odorless. It smells
Right.
From plain sight. Ooh.
You good?
No, it's a smell.
Yeah.
What kind of? Oh, he took the whole thing. Retail 1, vodka, family made. Retail 1, vodka, how many ounce? Took 1 beer.
Yeah, that's one beer, all right.
Yeah.
It sure is one beer, all right.
375 milliliter. Okay. Cattell 1.
Here's the beer can, too. Still cold, I bet.
Then he got beer too? Beer cans?
Empty can.
I'm gonna go ahead and read him, imply consent.
Okay.
And
Let me get the imposter.
yeah, right. Let's do that.
First time on a
1504 the radio.
It was black lightning. Yeah. And,
Here you go, LT.
Well, actually, she didn't blow it.
1504, you can go ahead and show one male in custody. Yes. Excuse me? Yes, sir.
Is there anyone that I can call before I go just to let someone know that he's a
Who do you need to contact?
my sister?
Okay, where's your phone?
My phone is
In
in the car.
the car. Okay, I'm gonna read you implied consent, okay? And after I read you this message, just answer yes or no, okay? All right. Georgia law requires you to submit to state-administered chemical tests of your blood, breath, urine, or other bodily substance for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to the required testing may be offered into evidence against you at trial. If you submit to testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the required state tests, you are entitled to additional chemical tests of your blood, breath, urine, or other bodily substance at your own expense and from qualified personnel of your own choosing. While you submit to the state-administered chemical tests of your breath under the implied consent law. What was that, sir? Yes. Okay. 1504 the radio.
And Judge, I'm gonna pause it at 28 minutes and 26 seconds.
Okay.
And Officer Tran, I just have a couple clarifying questions for you. Oh, thank you. And Officer Tran, I noticed in the video, State's Exhibit 1 that we just watched, that when after you arrested the defendant, you went back to his vehicle prior to reading implied consent. And my question is, why did you do that?
So Lieutenant Peterson actually grabbed my attention. Normally for me, I was taught that as soon as they get into custody, you read them implied consent. But I guess that time he, caught my attention. It's like, hey, Tran, get over here. I have something to show you. So I guess in the moment I got distracted.
Okay. I don't think I have anything further on direct examination, Your Honor, just maybe some redirect.
Ms. Rosenhuber, your witness will cross.
Excuse me, thank you.
Are you able to hear me, Madam Court Reporter?
Yes.
Thank you. Good morning, Officer Tran.
Good morning.
I want to begin by talking about everything you learned when you got on scene. Mr. Cotman was already handcuffed, right?
Correct.
He was sitting on a curb.
Yep.
Right next to his car.
Yes.
And then you spoke to Lieutenant Peterson.
Mm-hmm.
Is that a yes?
Yes.
And you also spoke with Sergeant Mitchell.
Yes.
You asked them, who was the first one who walked up to this person's vehicle?
Correct.
And they gave you the name of a completely different officer.
That I do not recall.
Okay, we did just watch the video. Would you like to go back to refresh your recollection? Would that help?
Yeah, whoever name that was.
So just to be clear, do you remember, or are you forgetting the name of the other officer, or are you forgetting whether they gave you another name?
I just remember based on the report that it was Lieutenant Peterson and the other officer.
Okay, I understand that that may have been what's in your report, but back to my question, and upon reviewing the body camera footage, the officers gave you a different name, right?
The audio was kind of low, so I didn't hear the other name.
No worries, Judge. I have it pulled up on my computer. If I could have permission to approach the witness.
Any objection?
No, I mean, he said he doesn't remember, so.
Go ahead, Ms. Rosenau.
Thank you, Judge. And for the record, I am going to, well, I have to play it and then skip to 2 minutes and 57 seconds.
Okay.
And I'm going to hold this up to the microphone with the sound.
Were there any who was the first one that walked up to his vehicle?
So I'm going to pause it right there. Were you able to hear that?
No.
Okay, I can try to do it again. Or would it be helpful if I handed you my computer and you can listen really carefully?
Yeah, we can do
Okay.
that.
Permission to approach the
You may.
witness. Okay.
Right.
I know it's difficult to hear, but I rewound 10 seconds, so I'm gonna hit play and just try to listen as best you can.
Yep.
I may have cooked it. Please hold. I wish technology was smoother than this. I really do.
Trying to stop close to it, very close size.
So you told him to deter traffic once, and then he came back. And then you guys, he didn't hit anything. He just blew through.
Everybody jumped all the way.
Were there any who was the first one that walked up to his vehicle?
Once.
Like, you know,
Were you able to hear it that time?
I heard like a lieutenant something.
Would it be fair to say, after reviewing that, neither Sergeant Mitchell nor Sergeant Peterson said that they were the ones that approached the vehicle?
He's Lieutenant Peterson, but yeah, I heard like Lieutenant something. I'm assuming that's Lieutenant Peterson. I don't know who the other officer is.
Okay. Well, after they gave you that name of a different officer, you told them, hey, I need to speak with that guy, right?
I don't recall.
Okay. Judge, I'm going to go to minute 6 now. And I understand that it was hard to hear. Believe me. But for purposes of the record, minute 6, second 08. Okay. Okay, and Officer Tran, I'm going right up to the 6-minute mark and I'm gonna come back over to you, okay?
I got you.
first one that saw him. Yeah, let me, because I want to, yeah, I just want to make sure everything is correct and, you know.
You have an imposter? I'll start it.
Yeah,
I do.
Okay. Let me ask the question again. After listening to that, didn't you say that you needed to speak with a different officer?
Uh, I'm not sure. The audio was not too clear.
Judge, I'm not quite sure how to deal with the audio.
You move on, Ms. Rosenhuber.
And just keep going.
Yeah.
Okay. And just to be clear, Officer Tran, the only two officers that you do name in your report are Sergeant Mitchell and Lieutenant Peterson, correct?
I just want to make sure I get their ranks correct. I don't want to omit ranked, like a police thing. Yep. It's going to be Lieutenant Peterson and Master Patrolman Mitchell. Yeah, sorry.
Thank you. But to answer my question, those were the only two officers named.
That was the only two that I put in the report. Yeah, so I guess.
Okay. Now I want to move on and talk about something else that you wrote in your report while you have it in front of you. You wrote that Lieutenant Peterson saw my client reach over and appear as though he was hiding something, correct?
Yes.
Okay. And then, but in fact, Mr. Peterson or Lieutenant Peterson told you that he wasn't the one who even stopped Mr. Coffin, right?
I'm just going based on collective knowledge.
Okay. And he also told you that he was on the other side of the street when Mr. Cotman was stopped, right?
I don't recall.
Well, going back to that line in your report about something being hidden, in the very next line, you wrote that Lieutenant Peterson said he later saw an open alcohol beverage container behind the passenger seat, right?
Yeah, I'm assuming that's when after we got him in handcuffs. Or
Well, let me ask you more specifically.
Yep.
In paragraph 4, line 3, or paragraph 3, line 3 of the, you write, Lieutenant Peterson said he saw an open alcoholic beverage container behind the passenger seat, right?
1, 2, 3, 4.
Page 4, paragraph 3.
Page 4. Paragraph 3. 1, 2, 3. Yeah, it could I read the report verbatim?
You may.
He says, Lieutenant Peterson stated he later saw an open alcoholic beverage container behind the passenger seat.
Okay, thank you.
Yep.
But you're aware that that alcoholic beverage container wasn't discovered until much later than that, right?
Correct.
And they actually found that after you had arrested Mr. Cotman.
Correct. So, no, go ahead.
So you acknowledge that no officer told you that they had seen an open container prior to that point.
Correct.
And to be clear, that can of Miller High Life was empty.
I don't recall.
If you could refer to page 5, paragraph 5, line 5 of your report, did you say that the Miller High Life can was empty?
And just move it back to like 3 p.m. today.
Yes, the report said it was empty.
Okay. And so was the bottle of Kettle One that you recovered, right?
Yes.
Now going back to when I know I'm jumping around, but when you first got on the scene, Lieutenant Peterson said that my client drove through a police barricade, correct?
That's what everybody on scene told me, yes.
And they told you that my client didn't hit anything.
Correct.
They told you that he complied with their instructions to pull over.
Yes,
And Lieutenant Peterson and Sergeant Mitchell told you that there was an odor of alcohol coming from the vehicle, correct?
I think either, because I normally say alcoholic beverage.
Okay. But to answer my question, there was an odor of an alcoholic beverage coming from the vehicle.
Correct.
And at one point, when you got on scene, you started looking in the vehicle, right?
Yes,
Used your flashlight to try to see if you could find anything.
correct.
Okay. You checked the front of the car,
Yes.
checked the back of the car.
I kind of just shine the light. Yes.
Okay, and you did that for about a minute.
Give or take. Yep.
Sure. And you said to the officers that you weren't supposed to search it.
Correct.
And Sergeant Mitchell suggested that you could search it, right?
I just remember that it's, hey, listen, we do plain view, and don't search it yet. More like,
Well, isn't it true that on the recording, Sergeant Mitchell actually says you can search incident to arrest?
yeah, well, I'm sure he said it, but I don't know if he searched it or not. I was with the defendant.
Sure, but you're sure that he said that at that moment?
Yes.
Okay. Now I want to talk about what else you did before you ever interacted with my client. We already know that you spoke with the officers, right?
Yep.
And you talked about specifically what you were going to charge Mr. Cotman with.
Yeah, at the time, I was just coming up with an idea of how I'm going to move forward with the case.
Sure, and specifically you said least I can do is DUI less safe.
Correct. I was trying to figure out what was going on.
And then you walked back to your vehicle to get a notepad.
Mm-hmm.
And you came back to the officers.
Mm-hmm.
And is that a yes?
Yes.
And you took notes about the charges that you were going to fill out?
Yes.
Okay. And you even called a tow truck for Mr. Cotton's vehicle.
Yes.
And then you told Lieutenant Peterson you were going to bring in an impound slip
Yes.
for the vehicle of Mr. Cotton.
Yes.
And when you called that tow truck, Mr. Cotton wasn't more than 10 feet away from you, right?
Correct.
And a few seconds after that, you walked back up to the officers.
Yes.
They were talking about their children.
That I don't recall.
They weren't talking about the investigation, right?
Yeah, I'm guessing.
Okay. And you asked if you could get Sergeant Mitchell's contact information.
Yes.
And then you did write down Sergeant Mitchell's information.
I got his badge number and name and stuff. Yeah.
Sure. And then about a minute after that, you walked over to Lieutenant Peterson,
Yes.
who was standing over Mr. Cotman at the time.
I'm assuming yes.
Would seeing your body cam refresh your recollection?
Sure.
Okay. Judge, just for the visual purpose, I'm going to move to minute 8. 58, and I'll mute you. Judge, I'm going to show Officer Tran and the state minute 8 at 48 seconds.
Yep.
And I'll just ask you that question. When you walked back up to Lieutenant Peterson, he was standing over Mr. Cotman, isn't that correct?
Correct.
And you asked Lieutenant Peterson if you could get his contact information.
Correct.
And Peterson asked you, who's your watch commander right now?
Yes.
And you told him.
Yep.
And he asked, what other sergeants work in your department?
Yes.
You told him.
Yep.
During that conversation, Mr. Cotman was still sitting on the curb.
Right.
At this point, you had not spoken to him.
Not yet.
You hadn't observed him walking.
Nope.
You hadn't even heard him speak.
No.
You hadn't smelled alcohol on his person.
No.
Okay. Now I want to talk about what you did when you first attempted to talk to Mr. Cotman. You finally started to address him about 9 minutes and 39 seconds into your investigation.
Yes,
And you said, hey, but then you cut yourself off, right?
I'm assuming yes.
And then you asked if you could speak with Lieutenant Peterson.
Mhm.
And you pulled him aside.
Okay. Yes,
Yes?
yes.
Okay. And you admitted to him that, in your words, you're awful at doing DUI.
I didn't say.
I'm gonna object. I think that's a mischaracterization of his testimony. I don't think that's what was said.
I don't-
Sustained.
I can go to 10 minutes and 13 seconds. We'll get the specific language. I apologize if I'm a little bit off. Here. And Judge, for purposes of the record, I'm starting at minute 10, second 12.
You may.
I'm all for,
Oh. Sorry. English is my second language. To clarify what I was saying, all for DUI. That's what I didn't.
Okay.
Yeah, I know.
I did mishear it.
Yeah,
I
it's,
apologize.
yeah, I'm all for doing DUI. Yeah.
Well, thank you for clarifying. So
Yeah.
you said that you admitted to him that you were all for doing a DUI.
Yep. And then I started addressing about the handcuffing issue.
Yeah.
And
And
then,
you,
oh, go ahead. Sorry. Go ahead.
no, I didn't mean to cut you off. What were you going to say?
And yeah, I was explaining to him, I was taught, hey, listen, they're in handcuffs. And then he explained to me, no, we're handcuffing him for safety reasons.
Right. And this was all 10 minutes into you even being there.
Yes,
And at this point, you hadn't even spoken to Mr. Coffin.
correct.
And in your words, procedural wise, you didn't know how to move forward
Correct.
because you thought he was already arrested.
Yes,
And when Lieutenant Peterson clarified that he was just being detained, you said, okay, we'll work with that.
yep,
And it was only after that discussion that you finally interacted with Mr. Cotman for the first time, correct?
yes,
I want to talk about what happened when you finally did interact with him. You asked him his name.
yes,
You had him follow you over to your patrol vehicle.
yes,
You began to question him.
yes,
You asked him where he was coming from.
yes,
He said home.
yes,
You asked where home was for him.
yes,
He said Ellenwood.
yes,
You asked where Ellenwood was.
yes,
He said east of Atlanta.
yes,
You asked what he was doing here in Atlanta.
yes,
He said he was visiting a friend.
yes,
You asked where his friend lived.
yes,
He said in town suites.
yes,
You asked where in town suites was.
yes,
And then he told you he wasn't totally sure, right?
yes,
And he said that he wasn't totally sure because he was simply following his GPS, correct?
yes,
You also asked him whether Mickey Mouse was a cat or a dog, right?
yes,
And he told you that Mickey Mouse is a mouse.
yes,
Okay. Now I want to talk about Mr. Cotman's demeanor throughout the duration of that questioning. He responded to all of your questions.
yes,
He's calm,
yes.
maintained eye contact with you.
I'm assuming, yes,
Well, based on your memory and from rewatching the body camera footage, he was maintaining eye contact, right? Okay. He wasn't slurring his speech.
No.
And throughout this entire interaction, the other two officers were also standing right there with you.
yes,
And then you advised Mr. Cotman you would like to begin field sobriety tests.
yes,
You didn't ask him if he wanted to perform them.
I just took the nod from the head as yes,
Well, to be clear and to respond to my question, you didn't ask him a question.
no,
Okay. And you didn't advise him that he didn't have to perform them, right?
no,
You told him that you would like to do that.
Correct.
Now I want to talk about the two tests that you did.
Mhm.
You explained the walk and turn test.
Mhm.
And Mr. Cotman asked for clarifications at one point.
I'm assuming yes.
Okay, and your response was just do what I showed you earlier.
Yes.
And Mr. Cotman completed that test.
Yep.
And he didn't fall over as he was attempting to complete them, right?
Correct.
Okay. And after that, you moved on to the one leg stand.
Mm-hmm.
The other two officers were still standing right there with you the whole time.
Yep.
And he was able to complete the one leg stand.
Yes.
For a full 50 seconds, he was able to keep one foot off the ground.
Yes.
And he counted out loud clearly.
Yes.
He wasn't slurring his speech.
No.
He remained upright.
Correct.
And then you told him to stop.
Yep.
And you told him to turn around,
Mm-hmm.
place his hands behind his back,
Yes.
and you placed him back in handcuffs.
Correct.
Now, on direct, you weren't sure whether or not you told him he was under arrest.
I told him eventually.
Did you tell him you didn't tell him when you placed him back in handcuffs, right?
I told him that based on the information, I'm putting him in, for, while he was operating the motor vehicle, he was, drinking and driving basically.
So just again, to respond to my question, you didn't use the word arrest.
No.
Okay. Now I want to talk about what you did after you placed Mr. Cotman back in handcuffs.
Okay.
You put him in the back of your patrol car.
Yep.
23 minutes into your investigation, right?
Yep.
And in the very next line of your report, I apologize. Let me back up. In your report, you have it in front of you. You said that you placed Mr. Cotman under arrest, right?
Second. Yes.
And in that very next line, you say that you read him the Georgia implied consent for people over the age of 21.
Correct.
But that wasn't the very next thing you did, right?
No.
Instead, in your words, you got distracted.
Right.
Lieutenant Peterson called you over to Mr. Cotman's vehicle.
Yep.
You began to search that vehicle.
Correct.
Okay. And you also returned to get an impound slip for Lieutenant Peterson.
Yep.
You radioed to dispatch that you had one male in custody.
Yep.
And it was only after all of that that you read the implied consent notice.
Yep.
That was 27 minutes and 10 seconds into your investigation.
Yes.
I have no further questions.
Redirect.
No, I don't have any redirect, Your Honor.
All right. May the officer be released.
Mhm.
Thank you, Officer Tran. You're free to go. Appreciate it.
All right. Thank you.
All right. Anything else from the state?
Just argument, Your Honor.
All right. Anything from the defense?
Hey, Judge.
All right. Argument. Who would like to go first? I think the state concludes, so.
Judge, since we're here on my motion, do I have the opportunity to go first and last?
Well, they have the burden of proof.
You wanna go first?
I'll go first and last.
Okay.
All right, Judge, we are here, I believe, on a couple different issues. I'll start with, in the defense's motion, RAS for the stop of the vehicle. The state contends that we have satisfied that there was reasonable articulable suspicion to stop the defendant's vehicle. You heard testimony from Lieutenant Peterson that him and Officer Mitchell were working an off-duty movie set for the Bad Boys 3 movie when the defendant driver drove through the barricade while they were filming the helicopter explosion scene. And based on that, that's enough to at least approach the defendant and get him to stop his vehicle. So we satisfied RAS. In terms of a prolonged detention, it's the state's contention that there has not been a prolonged detention here. The testimony you heard in the video evidence that was admitted as admissible evidence is what Lieutenant Peterson and Officer Mitchell stated, that when they made contact and the defendant finally got removed from the vehicle. One, they removed him because of the safety for himself and the other officers. They had no idea why he drove through the barricade. And as you heard Lieutenant Peterson say, it was extremely dangerous to do so, as there was explosives that were on scene. There was multiple people out. People were flagging him to have him stop. So it was a danger posed to the officers and to the defendant himself. That's why they removed him and detained him temporarily in handcuffs. And during that interaction, they observed that the defendant also was reaching around in his vehicle. The officer didn't know what he was reaching for. And that is shown on the body camera footage that was admitted into evidence. And Lieutenant Peterson also testified to that. They also observed the odor of alcohol coming from the defendant. Lieutenant Peterson testified to that and testified that the defendant's motions were sluggish. That in and of itself, Your Honor, is RAS to continue a detention of the defendant until Officer Tran arrived. And you heard Lieutenant Peterson testify that when they were working the movie set, Lieutenant Peterson wasn't able to continue with a DUI investigation because they were taking care of the movie set and they were off duty at that time. And it's their practice to call in the Zone 5 officer or sergeant. And you heard testimony from Lieutenant Peterson that Officer Tran arrived within minutes. And so based on the fact there was RAS for a continued DUI investigation, we have shown that there's not been a prolonged detention. In terms of probable cause for arrest, Your Honor, I will speak to the fact that the driving manifestations that were testified to, the odor of alcohol that was testified to, the Lieutenant Peterson's testimony that the defendant displayed slow and sluggish and he thought he was under the influence of something. The performance on field sobriety evaluations, Officer Tran testified that in what was shown on video, that he did not follow the walk and turn instructions. I think he actually took more than 8 steps. He walked all the way down the road, as well as you heard the clues that Officer Tran testified to. And also that he smelled an alcohol on his person as well. The defendant also admitted to driving, admitted to drinking 1 beer 30 minutes prior to the incident, and also admitted on a scale of 1 to 10 that he was at in an intoxication level of 3. So probable cause has been met based on all of those observations and the testimony from Lieutenant Peterson and Officer Tran. In regards to voluntariness for fields, I think the video speaks for itself in terms of the voluntariness for the performance on field sobrieties, the video evidence and the testimony from Officer Tran. He was never threatened. He was never coerced. He was never yelled at, screamed at. I know that there were 3 officers standing there with him. But if you look at the voluntariness factors, Your Honor, just the presence of a number of officers is not in and of itself involuntary. And if you actually look at the video footage, Officer Peterson and Mitchell are in the back standing, not even really paying attention to the defendant performing field sobriety evaluations. It was rather just Officer Tran and the defendant engaging in that evaluation, Your Honor. In terms of the custody issue, Your Honor, it's the state's contention the defendant was not in custody. Thus, Miranda was not required during this DUI investigation. You heard the testimony from Lieutenant Peterson that him and Officer Mitchell did detain the defendant given the nature of his driving manifestations and his actions of driving through a barricade. You heard that it was extremely dangerous. They temporarily detained him in handcuffs until for his safety and for the officer's safety. That was a temporary detainment. Officer Peterson testified that he told the defendant, he never told the defendant he was under arrest, and they released his handcuffs when Officer Tran got there. They took him out of handcuffs. And you have to look at a reasonable person standard, Judge. The subjective thoughts of an officer are not relevant when we're looking at whether someone's in custody, or the subjective thoughts or statements of an officer. You look at a reasonable person standard, and for safety reasons, they had him handcuffed but did remove them. And he was not placed in the back of a patrol car. He was able to sit down on the curb. He was not constantly monitored by a police officer. There wasn't an officer standing over him the entire time. And so the state's contention is that he was not in custody for purposes of Miranda. Everything in terms of the DUI investigation was performed voluntarily. In support of my position, for those, Your Honor, I have a couple cases. State v. Price, 322, Georgia App 778. And that's a 2013 case where the court held that the defendant was not in custody when the defendant was removed from the car and handcuffed while the investigation continued. Additionally, in Smith v. State, 281, Georgia 185, the Court of Appeals recognized that officers may handcuff a suspect during an investigatory stop when such action is either reasonable under the circumstances to protect themselves or the public, or to maintain the status quo. Again, State v. Austin, 310, Georgia App 814. The court found no violation of the defendant's right when the defendant was handcuffed for purposes of officer safety, and explicitly told that he was not under arrest and that the handcuffs were just for the defendant's own safety and the officer's own safety. And a case for prolonged detention, Your Honor, Rebuffy v. State 335, Georgia App 858. The court held that where a defendant was detained for approximately 23 minutes in order for a DUI officer to arrive, the court held that a delay twice as long as 23 minutes, didn't convert the investigation into a custodial situation. Moreover, the defendant was permitted to sit or stand and was told he was not under arrest. And I believe those cases do support the state's position. And to my final point, Your Honor, in regards to implied consent, the defense has claimed that it wasn't read timely. OCGA 46-392 reads that the arresting officer at the time of the arrest shall advise the person of their right to a chemical test according to implied consent. The Supreme Court in Georgia interpreted that to basically mean implied consent has to be read at the time of the arrest or at a time as close in proximity to the instant of arrest as the circumstances of the individual case might warrant. So it doesn't have to be simultaneously the second that you put handcuffs on someone and tell them that you're under arrest. It has to be in as close proximity as the situation warrants. The video evidence showed that the defendant was taken into custody and arrested about the 23-minute mark. You see immediately that Officer Tran was called over to Lieutenant Peterson to further investigate the open containers in the car, which is a search incident to arrest. The investigation at that point was still ongoing as they were determining what was going to be in the car before it was going to be towed. An implied consent was read, I think, maybe less than 4 minutes later. That is not an unreasonable delay by any means, considering that the investigation was still ongoing and they were searching the vehicle subject to incident to arrest. And the case that I would have the court rely on is Dunbar v. State, 283, Georgia App 872. And in that case, there was a 25-minute delay in reading implied consent, and the court held that that was not unreasonable given the circumstances in Dunbar when the officer arrested the defendant and went back to Dunbar's vehicle to further investigate the scene. And the court held that a 25-minute delay in reading implied consent was not unreasonable. And again, in Brown v. State, 265, Georgia App 129. There was a 4-minute and 47-second delay in reading implied consent when the officer went back to the defendant's motorcycle to check to see if there was any weapons or to check for his identification. And the court held that was not an unreasonable delay. Based on all of that, Your Honor, in the case law, I'm asking that you deny the defendant's motion to suppress on all grounds.
All right. Ms. Rosenberg?
Your Honor, I have provided the court with the cases that I'll be referencing in the way that I'll be referencing them. As a starting position, Mr. Cotman was already under arrest when Officer Tran arrived. The rule for determining whether a person has been placed under custodial arrest is whether a reasonable person in the suspect's position would have thought the detention would not be temporary. And in that, I'm citing Saluki v. State 302 Georgia Act 735. The court in Saluki applied the test and found that even though officers claimed the defendant was merely being detained, the circumstances would lead a reasonable person to think that the detention was not temporary, and the evidence in that case was suppressed as a result. In addition, in that particular case, defense counsel was deemed ineffective for failing to raise that issue in a motion to suppress. The distinguishing cases that I've printed out and provided for Your Honor that are actually state-friendly cases are Peterson v. State 337 Georgia Act 159 and State v. Holt. And Judge, in the Peterson case,
Tell me about prolonged detention under Mullins. Why do you believe it's applicable?
about specifically under Mullins, Judge. The court in Mullins v. State held that the evidence obtained as a result of the traffic stop was inadmissible. In that case, the defendant was being investigated for a prior day's break-in. The officer took time to review the video, and then they eventually declined to eventually the defendant declined to consent to a search. The officer said the defendants would have to wait while they obtained a search warrant, and the court there reasoned that detention was prolonged because an investigative detention must last no longer than is necessary to effectuate the purpose of the stop, and the methods employed should be the least intrusive means reasonably available.
And that tenet, why do you believe is applicable to this case?
Judge, in this case, the officers were more focused on the things that come after an arrest than on investigating a DUI. There is no reason why it should have taken Officer Tran 12 minutes to even speak to a person who's being handcuffed and sitting on the side of a curb and waiting to be spoken to about an alleged DUI investigation while they call a tow truck, talk about who works with them. Judge, there are any number of things. They were looking in the vehicle, just hoping to see some kind of open container, which they didn't even find until well after the fact. Anything that veers them from the time reasonably required to fulfill the purpose of the stop prolongs the stop. The court has not set any bright line or time restriction rules. The fact it could have been 10 minutes, it could have been an hour, and courts could differ depending on what the officer's mission of the stop was and how diligently they pursued that mission. And here, Judge, the evidence that you saw clearly shows that the officers did not diligently pursue the mission of this stop, which was apparently a DUI investigation. But Judge, I still argue that Mr. Cotman would have reasonably thought that his detention was not going to be temporary, and for that reason, he was under custodial arrest before Officer Tran even arrived. But certainly, if the court finds that he wasn't under arrest until Officer Tran put him in handcuffs, the detention was still certainly prolonged under Mullins v. State and even in distinguishing State v. Holt. Further, Judge, when it comes to implied consent, I'll jump around. The law requires that the rights be read at the time of the arrest or as close in time or in proximity as circumstances of the individual case might warrant. Ms. Reiser did say that, but Judge in Austell v. State, at that point, they had the difficulty of having to deal with calling a wrecker. The individual was unsteady on his feet, stumbling around. The officer ended up wrestling a person to the ground, the defendant to the ground, before putting him in the back of the vehicle. And even then, it was still unjustified to wait for another officer to arrive on scene or get the person to the station before reading implied consent, because the statute requires that it be timely read. And the court there found that there were opportunities for the officer to read implied consent prior to actually getting him to the station. Here, Mr. Cotman was perfectly cooperative. I would argue that he wasn't manifesting physical signs of intoxication or impairment, as the defendant in Austell was. Officer Tran could have read it to him the moment that he put him in the back of the patrol car, and instead he decided to go on a fishing expedition and look for more evidence in his vehicle. And Judge, for that reason, the breath test should absolutely be suppressed in this case. Jumping back to the probable cause arguments, I have provided the court with a few cases. While we'll acknowledge that the officers did have reasonable articulable suspicion to conduct a traffic stop and initiate the DUI investigation, they certainly did not have probable cause to make a DUI arrest when they placed him in handcuffs. I would argue they didn't have it when they pulled him out of the car and handcuffed him the first time, and they didn't even have it when Officer Tran handcuffed him the second time. The courts in State v. Blanchard and State v. D'Amato emphasize that the mere presence of alcohol is insufficient for probable cause that a driver was driving under the influence of alcohol such that he was unsafe to drive. I'd point the courts to both of those where there were more factors of a DUI that could have contributed than we had in our case here. Further, Judge, looking at the voluntariness element, I want to emphasize that voluntariness must reflect an exercise of free will and not merely a submission or acquiescence to the express or implied assertion of.
Excuse me. Can you slow down a bit, please?
Yes, I apologize. I'll start back with not merely a submission or acquiescence to the express or implied assertion of authority. And the courts have found that no single factor is controlling. I know that courts have laid out a number of factors for the courts to consider for voluntariness, but there is not one single factor that drives. And Judge, I would argue that all of the factors that I would also argue pointed towards Mr. Cotman's reason to believe that his detention wasn't temporary. All the de facto arrest factors also apply for voluntariness and the mere acquiescence to authority. When you have three officers standing around you, you've just been sitting in handcuffs for 12 plus minutes. We're not sure how many minutes he was sitting there prior to. The officers have called the tow truck for his vehicle. It's about 10 feet away from him, clearly in earshot. He knows he's not going anywhere other than jail. And he knows that he has no choice but to comply with what they are asking him to do.
Judge, I'm sorry, I know it's closing and I don't need to cut Ms. Rosenhuber off, but I think she's testifying to facts, not in evidence. What her client felt during that time needs to come out of his mouth in his testimony. So I think her arguing that he overheard something is not appropriate because that wasn't the testimony that was presented. So I just have an objection to facts, not in evidence.
Overruled.
And Judge, we heard through the officer's testimony that Mr. Cotman was sitting 10 feet away from Officer Tran when Officer Tran called the tow truck. We also saw that on body cam footage. And Your Honor is welcome to go back and review that footage and see exactly where he was positioned when officers discussed what they were going to charge him with, when they called the tow truck, when they asked for an impound slip, when Officer Tran took down all of their information before even speaking to Mr. Cotman. There is no world where a reasonable person would have thought that he was getting out of that situation or that that detention was going to be temporary. And the fact that the officers 10 minutes in realized their mistake and realized, hey, he shouldn't actually be in handcuffs right now does not excuse the unlawful behavior. The fact that they were able to provide a justification does not excuse the reasonable person standard of what Mr. Cotman felt was going on. Ms. Reiser's right that it's not the subjective intent of the officers. It doesn't matter really whether they intended to have him under arrest, but we have to ask ourselves what a reasonable person in Mr. Cotman's position would have thought was going on when the officers are behaving like he's already arrested. And Judge, for all of those reasons, we're asking that the court suppress the statements that he made to Officer Tran, the breath test that was later submitted, the field sobriety test, and the evidence seized in the vehicle. Thank you.
Thank you. Ms. Reiser, your conclusion?
I just want to respond to a couple points in regards to the Mullins case for prolonged detention. There's not prolonged detention here. I think in Mullins, they were detaining that individual while they were waiting on a search warrant. Here, we have an active investigation still ongoing. So that 12 minutes that defense is contending that it took 12 minutes for Officer Tran to talk to the defendant. But you have to look at the totality of the circumstances and what was happening during those 12 minutes. It's not like Officer Tran got on scene and just sat down waiting to talk to the defendant. He was actively investigating. He was talking to the two witnesses to the defendant's driving, getting their information so he can be included in the police report, getting his bearings about how to approach the defendant. So it's an active, ongoing investigation, not a prolonged detention. And then in regards to the implied consent defense case, the Austell v. State, that's a lot different than the case we have in the present case, Your Honor. In Austell, they waited until they got back to the police station to read implied consent. And the court held that that was unreasonable because there was other times on the scene of the investigation where that could have been read. In our case, Mr. Cotman was still on scene. It was a very, very short, I wouldn't even say it's a delay, but a very short time between arrest and the reading of implied consent. While Officer Tran was still investigating, he was legally allowed to go and search the car and got pulled from after he placed Mr. Cotman in the back of the patrol car and arrested him. He was legally allowed to go search the car incident to arrest. And Lieutenant Peterson actually called him over and said, "Hey, I need you to look at this." So the investigation at that point was, it was all still unraveling. So we would still ask that the court deny the defendant's motion to suppress.
All right, thank you. I wish there was case law out there to literally fit every factual pattern that could come out of every possible DUI case. But unfortunately, they're not. And all these cases give us like timeframes, or this was too long to have detained an individual, or no, this is long enough. It ranges from 10 minutes to 48 minutes to over an hour to more than a day. So thank you for the appeals, but unfortunately, those are just guidelines. Those are not black letter law. There's nothing bright line about it. The standard is whether a reasonable person feels detained or in custodial arrest, given the circumstances and facts of each specific case. The trial court is not only the determinant of the facts, but also try to apply the law as it's based on the facts presented during the hearing. The law says that once a valid traffic stop has been effected, the Fourth Amendment prohibits the officer from unreasonably prolonging the stop beyond the time required to fulfill the purpose of the stop without a reasonable articulable suspicion of other illegal activity. A reasonable time to conduct a traffic stop includes the time necessary for the officer to perhaps run a check on the validity of the driver's license and registration, to check for outstanding warrants, criminal histories, to question the driver, the occupants, witnesses surrounding the stop, anything, the questioning that relates to not unreasonably prolonging the detention. We have Officer Tran who arrives and takes about 12 minutes before he even approaches the defendant. Now, taking the scene, Mr. Cotman did not help matters by going through a barricade. I don't know why he did it. I don't know what his mind frame was, but the point is there are sufficient officers there who are testifying that he was forewarned and he returned and he still went through a barricade, allegedly. So there was the rise to suspicion, reasonable articulable suspicion to effectuate a traffic stop. I don't have any problem with that. Then they removed Mr. Cotman, or he voluntarily stepped out of the vehicle. He was placed in handcuffs and made to sit on the curb, after which the officers then called for Officer Tran, who arrived. My concern is that I didn't understand what was the reason for the prolonged discussions with Officer Peterson and Officer Mitchell prior to approaching the defendant. I didn't see the validity. There were some questions about what you saw and so forth, but the biggest point that I got during that 12-minute discussion was that Officer Tran himself, in assessing the situation, considered the defendant to be under arrest. That is a very, very disturbing factor. Then he approaches the defendant, and while he doesn't make the defendant rise, he doesn't remove handcuffs. He starts having a discussion with Lieutenant Peterson about who is still at the office, who is still there, and I know this person. How is that related to the investigation purpose? I'm still baffled by the nature of the discussions that Officer Tran had with Lieutenant Peterson. After Officer Tran placed Mr. Cotman under arrest for DUI, he again did not read him implied consent within a reasonable time frame. Instead, he put him in the back of the police unit car, and then he said he was distracted by something in the vehicle. Note, everyone has been stressing to me that this is an active movie scene with pyrotechnics and helicopter. I watched that video for 27 minutes. I didn't see anything go up in flames. I did not see movie sets. I did not see movie personnel around there. I saw an open street. I didn't see any traffic. It was a clear day. There was no reason for exigency. There was no reason to say that anyone was placed in danger because a helicopter was about to land or pyrotechnics were about to go off. In fact, it appeared that the officers were securing the outer peripheral area of a movie scene rather than an actual active movie scene. So number one, I don't understand why Peterson placed Mr. Cotman in handcuffs. He could have had him standing by the car. He could have had officers securing him at the scene. I don't understand why Officer Tran did not read him implied consent as soon as he got there and he deemed the situation that the defendant was already in custodial arrest. And I don't understand why Officer Tran was distracted to look in the vehicle to look for an alleged open container when he could have read him implied consent, completed the arrest, and then gone to search the vehicle. I don't understand that because I don't see the exigency. I don't see the need to secure the defendant. I don't see the need to secure the scene. I don't see the need to secure any other lay witnesses or bystanders who may be in danger. There was absolutely no evidence. This was a badly handled arrest. I'm granting the motion to suppress. The charge of DUI per se is dismissed on the grounds that I'm suppressing the breath test. I'm suppressing the statements that Mr. Cotman made to Officer Tran, who already deemed him to be under arrest and failed to read him his implied consent at his initial approach to Mr. Cotman. I am going to amend the I'm going to dismiss it, but I'm going to add a charge of reckless driving that the state can accuse, and they are free to go to trial. I'm going to, since I'm suppressing the search incident to the arrest, the discovery of the open container by Officer Tran, I'm going to dismiss the possession of an open container as well. So there wasn't anything with regards to failure to have licensed in person, no evidence brought in with regards to that, so I'm just going to leave that. So the state can proceed on the charges of reckless driving, DUI less safe, and failure to have license in person. Please submit the proposed order. Ms. Rosenhuber.
Judge, can I clarify the court's ruling about the field sobriety test?
Oh, the field sobriety test are out also. Anything that was, any evidence that was obtained from the time that Mr. Cotman's handcuffs were released by Officer Tran. All right, thank you, folks. Was this my copy or your copy, Mr.?
Those are all three.
All right, folks, I have now a motion for a new trial on position 1. Ms. Allen, do you need a 5-minute recess or 10-minute recess?
No, I'm good.
Ms. Reiser? Folks, do you all need a 5-minute recess break?
We're not going forward on the motion to the new trial. We don't even have, they don't have a transcript.
Oh,
There's been no amended motion filed.
That is correct.
all right, hang on, let me get started first on that case. As soon as Ms. Rosenhuber. Isn't it? And Ms. Rosenhuber, is your client wanting a jury trial or a bench trial?
We'll need to discuss that for now. We can set it for a bench trial.
Okay. No, I need to know now, because if it's a jury trial, then we put it on the jury trial calendar. If it's a bench trial, we'll put it on the bench trial calendar, and that's what we're going to go with. I don't want him to show up for a bench trial and say, oh, you know what, I want a jury trial.
Let's go with jury trial then.
Okay. We're gonna reset position 2 for a jury trial. The state is free to amend the accusations accordingly.
Judge, I can't amend an accusation with,
No, I'm assuming by adding the reckless driving.
I can't, we're past the statute of limitations.
Oh, you're past it? Okay,
So
then we are.
the
then-
charges,
Then it's DUI less safe and failure to have license in person. And those are the 2 charges that are going to go forward. Ms. Bolton, may we have a case management order on those 2 charges? Thank you.
I mean, is he open to pleading to reckless or no? Is he open to pleading to reckless? Or- Okay. I mean, the only
Okay.
left would be to have license on person. I mean. Mhm. If he wants to plead it.
All right, Ms. Rosenhofer, we're done? Thank you. Ms. McLeod?
Yes, Your Honor.
Yeah. Okay. This is State v. Leonard P. Bennett Jr., charged with, convicted of simple battery domestic violence pursuant to a bench trial. Mr. Bennett is present with his attorney, Ms. Maureen McLeod. He's been advised, just to reiterate, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. And you are now represented by conflict counsel as previously directed by the court. All right, Mr. Leonard Bennett was represented by Mr. Frank Gaither of the Public Defender's Office. At the time of the bench trial, Mr. Gaither filed a motion for the new trial. We had a motions hearing August 18th, 2023, at which time Mr. Gaither indicated that conflict counsel would need to get involved, but he was also instructed at that time to obtain the transcript of the bench trial. All right, where do we stand, Ms. McLeod?
Your Honor, my understanding as of this morning is that the transcript is available, so I'm going to need some time to review the transcript.
All right, from whom is it available?
I just found out that it was available today, this morning, while I was in court.
I know, from whom? Who is the court reporter? Who's supposed to produce it?
Apparently, Mr. Gaither sent it to my client. My client informed me that it was available.
Have you spoken to Mr. Gaither?
I have not. I have not yet, Your Honor.
No, that doesn't tell me anything. I mean, if the transcript is available, it should be printed and produced and for everybody to review, because today was the motion for the new trial.
I understand, Your Honor. I looked at my emails and the last email I got was one saying that it was being requested and that I would be informed when it was received.
What was the sentence of this case? Ms. Bolton?
One moment, Your Honor. It was 12 months probation. Count 1.
Is that the order?
I believe it was time served and a year of probation. That's what my client tells me. One moment, Your Honor. Let me pull out the final disposition.
He was to enroll in FBIT within 60 days from today. So with all due respect, Ms. McLeod, I'm not putting a lot of credit on your client's representation of what's going on. He was instructed to make sure he gets counsel, and that was another delay from August 18th for him to retain you. He and both his former counsel were instructed to get a transcript, and now he's telling you at this late hour that one's available, but it's not producing one. He was specifically instructed to enroll in a domestic violence intervention program within 60 days from May 10th, 2023. Has he done so?
It tells me it's completed it. 20, I'm sorry, 20th to 24th.
When did you start your classes?
Your Honor, I began 2 weeks after court. I have an update that you completed one of the 24 classes I just said that.
Okay. That's all I wanted to know. Thank you. All right. So what are you asking for today, Ms. McLeod?
I'm asking for an opportunity to review the transcript. So I'm asking for continuance. And also my client tells me that there are 2 minor children that the parties have that you had indicated should be exchanged through a third party.
Mm-hmm.
He says that because there is no order saying that, he's not been able to find a third party to do that. So we would ask the court to consider issuing an order specifically stating that, so he'll be able to see the children.
Uh-huh. I can indicate that I can amend the disposition to add that. It wasn't added. Looking at the disposition, it says separate 60 days, no contact with Sonia Baker. Weapons are prohibited, and a specific note, but unfortunately, no, it doesn't indicate the contact with children. So I can amend the disposition to add that.
Thank you, Your Honor.
All right. So, and does he have a third party in mind?
He does, Your Honor. He has her brother and I believe his sister.
Give me the name of her brother.
Michael Chad Harper
Michael Chad Harper.
or Sandra Bennett Lewis, my sister, if possible, Your Honor.
We'd like to be able to see the children on the weekends.
No, I'm that y'all can just there's only third party transfer that has to be organized. I'm not going to get into visitation issues. If you believe that visitation and custody is a problem, then but it's going to be an arrangement made between the third parties on when the children can be picked up. Okay, Miss Allen, did you have that?
Yes.
Let me see. The other thing I wanted to. What's our next motions calendar?
One moment, Your Honor. We're pretty booked up. One moment, Your Honor. Just a second.
Well, let me put it this way. When's our next motions calendar that's already set?
December 15th, we have open spots for December 15th. But the next motion calendar for Friday, we have 4 out of 4 positions, but it's November 17th.
I'm not available on November 17th, so it have to be December 15th.
Yes, Your Honor.
And all right, as long as Mr. Bennett is still continuing his effort classes and he's having no contact with Sonia Baker, and I'll amend the disposition to include third party contact with the children, visitation and custody arrangements to be determined by the respective parties. And what else? And the transcript must be available. I'm going to put a deadline on this. You say it's available today?
My client has it, he would send to be copy. by Mr. Gator.
When?
When did you receive?
October the seventh, Your Honor, Mr. Gator forwarded it to me from his email. Be glad to. From his email is attached.
And when were you retained as appointed, Ms. McLeod?
It was in late September, Your Honor.
And this is the first time you're meeting your client, or have you had prior contact? You didn't have any prior contact?
No, Your
No
Honor,
phone, no email?
no.
The reason is, I'm just.
I don't know, Your Honor. I just received an email asking me if I would be able to represent them. I said yes.
And you understand what's for a motion for new trial? All right. Does the state have any objection to resetting to December 15th, and the transcript is to be made available to all parties, since you've got you have a copy of the transcript, since the state has the right to.
No, it has to be filed into the docket, and I don't know if it's filed into the docket yet.
All right, Ms. McLeod, you file it by Monday morning. All right?
Actually, I had it to them.
Yeah.
You mean the copy I received from my client?
Yes. Just the transcript. You file it and make it available to the state, and the motion for new trial is going to be addressed on December 15th at 9 a.m. And that'll be the first case out.
Yes, ma'am.
All right, everyone, you all are free to go. Enjoy the rest of the weekend. It officially begins 4 hours and 5 hours from today. Now, thank you, folks. You all are free to go.